Let's talk about employment at will, a concept that we hear a lot about, and I'm going to talk about what it is and how it works and what are some of the exceptions. So employment at will is a rule of contract law, which is state law. And the idea of employment at will, there's two things. One, the employee is allowed to quit at any time for any reason without giving any notice at all. Two, the employer can fire the employee at any time for any reason without any notice at all, without any kind of a hearing, and can do that for a good reason or a bad reason or no reason at all. And that's a pretty happy situation for employers. It's not quite so happy for employees. Now, when we look at the so-called exceptions, which are really things that override the rule rather than exceptions to it, one big one is, since this is a matter of state contract law, the employer and employee can write up a contract that provides for something different. Then you have situations where there's a collective bargaining agreement between a labor union and the employer, and typically those contracts have what's called a just cause clause, which provides that the employee can be fired only if there's just cause. So that gives the employee some protection. Then we have state statutes, statutes about whistleblowing, statutes that outlaw discrimination on the basis of sex and race and religion and disability. Likewise, we have federal statutes that outlaw discrimination based on race, sex, disability, age, and some other factors, which we'll go into in a later video. So we will be having some videos in this series discussing these factors that I've just called exceptions, even though they're not exceptions. So thank you for watching.